should seek some mental help. Because
I'm
something's
sorry?
wrong with you. You have
You
a
said
mental
what?
you have a mental problem.
I
If
have
you
a
think
mental
the laws
problem.
of
How?
the United States don't apply to you, and you get to make them up as you go along, like you know more than everybody else in the world, there's clearly something wrong with you.
No, what did I make up?
All of it. Good morning. The 14B District Court is now in session. My name is Elaine Washington.
I find everyone's pain funny but my own. I'm French.
Mr. Fantera, if you, the court will call the case of the Ranches of Rosebrook versus Anais Battle, case number 25C-1245.
Good morning, Your Honor. David Fantera on behalf of the plaintiff.
Battle, please unmute and state your name.
Anais Battle, appearing especially, not generally.
Thank you. All right, we're here for the continuation of the hearing today. Battle, when you're not speaking, please.
You said, can I mute my mic when I'm not speaking?
Correct. Thank you. All right, Mr. Fantera, I believe that we are in the middle of your, well, actually it was Ms. Battle's direct.
Yeah, I think Ms. Battle was cross-examining Ms. Charles.
That's correct. Ms. Battle, are you ready to proceed?
Yes. So, Don, do you have a signed lease between me and you in this case?
Yes.
Did I ever waive my rights or agree to the terms in writing?
What's the question?
Did I ever waive any of my rights or agree to your terms in writing?
Your Honor, I object. I have no idea what that means.
Meaning that there are waivers inside of the lease.
Your Honor, she's got a signed lease. That lease was, we moved to have that admitted last time, and it was admitted. Ms. Battle did not object. So I don't know what she's asking right now when she talks about a waiver. She signed the lease.
Okay, that's fine. Are you aware of the notice of rescission that was sent?
Yes.
Your Honor, I object. Rescission, we can't go down this road again.
Why are we not going down the road?
Let him finish his objection, please.
Okay.
Your Honor, this case is not about rescission. It's about, this is a non-payment of rent, pay and stay case. The question is, how much money does she owe in order to stay in her lease? She believes, and she stated, and she was overruled by Judge Vandenberg, and I believe by you, that her belief that she rescinded her lease and therefore she gets to stay until she finds a new place is not the law, and she should not be allowed to pursue that line of questioning. This is not about rescission, which, by the way, she hasn't done anyway.
All right. So your argument is that her question is not a legal question and therefore you object.
It's not based upon law.
It is based upon, what law is it not based upon? It's based upon common law. You have not proven or stated any laws or facts that back what you're saying. Unlike me, I have.
Yeah, but you stated them all wrong. And one of the things you stated was the Magna Carta, which was from the 12th century in England.
No, I stated it under common law
Please
and
stop.
landlord-tenant acts.
That's not, we're not under common law anymore, ma'am. And that's a part of the problem with sovereign citizens. They think they know the law when they don't. That is
well,
not.
That sounds prejudiced and biased because I'm not a sovereign citizen. So it seems like you're trying to group me in with them, and that I am not.
Today, we dive into a courtroom showdown where Judge Washington takes on a sovereign citizen, Karen, who believes she can outsmart the system with buzzwords and broken logic. The judge is calm at first, but quickly starts peeling back the nonsense. With precision calling her out for making up laws, citing outdated charters, and misusing legal terms. The moment Karen says states don't apply to her, you can feel the temperature in the room change. Judge Washington lets her know point blank something is wrong with her, and it's not just legal confusion, it's a complete disconnect from reality. She thinks she's teaching the court a lesson, but she's the one getting schooled. Her tactics mirror those of other sovereign citizens, demanding jurisdiction challenging contracts, waiving rights. They don't understand she waives the lease, but still lives there, argues over definitions, but misses the law entirely. Judge Washington finally reaches her breaking point, and what follows is one of the most brutal verbal takedowns we've ever seen in court.
Whatever you're using as your basis is still not correct. It is not the law.
It is. It's still under
Okay,
MCL
not
and it's under the Landlord-Tenant Act.
overruled.
My objection is overruled, Your Honor.
No, the objection is sustained. Her question, it cannot be asked.
So you're saying I can't ask about the contract that's in question?
No, I'm saying that you have no basis for asking whether the contract was rescinded or not.
Why would I not have basis for asking if the contract was
Because that's
rescinded or
not
not?
the law. You don't get to unilaterally rescind anything, ma'am.
Well, again, as I stated,
My ruling, I'm not arguing with you anymore about it.
right, it's not an argument. So just let the record show that there is no law or basis to what she's saying. And she has not yet stated any law or fact behind this objection to
Ma'am,
asking these
please
questions.
move
I will
on.
continue. I will continue. Okay. Did you write me a notice to quit filing this action?
A notice to quit?
Yes.
No.
I think she's referring to a demand for possession,
A
Dawn.
demand for possession, yes.
No, a notice to quit.
No.
Right. Do you have proof of delivery or service of any notice to quit?
No, I didn't send one.
Right. Are you aware that MCL 657-16 requires a notice to quit before initiating an eviction?
Your Honor, I object. Miss Battle is confusing the term notice to quit with demand for possession. A notice to quit is how you start a termination of tenancy case. This case was started with a demand for possession. If Miss Battle wants to use the wrong term, she's going to get the wrong answer. The statute says that we can start a non-payment of rent case with a demand for possession, and that was issued. And if she asked that question, Ms. Charles can answer that question.
Is there proof of service? Is there proof of delivery on that demand for possession?
Miss Battle, can you do me a favor, please, ma'am?
Yeah.
Give me one moment. You cited a statute that I actually need to look at. MCL, what
I'm sorry.
was the statute that you cited?
MCL 657.6. I mean, not 57.6, 600.5716.
That a notice to quit is required for eviction, completely ignoring that in non-payment cases a demand for possession is all that's needed. She keeps confusing the law and then doubling down as if confidence can override facts. The judge and attorneys try to guide her, but she fights them at every turn. She cites laws that don't apply, then denies ever citing them moments later. It's courtroom whiplash. She talks over people, misquotes statutes, and constantly plays victim like everyone is against her, when really they're just enforcing the law. She claims the judge is biased and the landlord is breaking HUD rules, but when pressed admits she doesn't even receive HUD support. She throws legal spaghetti at the wall hoping something sticks, but none of it does, and Judge Washington grows more exhausted by the minute. Still, the judge gives her space to ask questions, but Karen just spirals deeper into a delusion of legal fantasy.
Have you read that statute?
Yes, I had read it when I first did this.
It uses the term demand for possession.
Okay, everybody please stop talking. It says, a demand for possession or payment shall be in writing addressed to the person in possession and shall give the address or other brief description of the premises. It's a demand for possession, not a notice to quit.
Okay, so is there proof of service of it on the record?
That's a different question though. So, okay, go ahead.
But that's the question I asked next. Once he said that the
But I
demand for
wanted to
possession,
clarify your question before.
I appreciate it.
All right, Ms. Charles, please add, her question next is there proof?
Do you have a proof of delivery or service for that demand for possession?
Nope.
Nope. Did you know that under MCL that you're required to have a certificate of service or proof of service on the record?
Your Honor, I object. She's now, again, she's not using the statute changed 10 years ago so that you now need, on a demand for possession, a certificate of service. And that's what's at the bottom of the page. If she's looking for a proof of service, meaning somebody going to the door, she's going to get the wrong answer again. The term is certificate of service, and I believe Ms. Charles will answer that question differently because there is a certificate of service at the bottom of the demand. So I would appreciate if she's going to cite statutes, she cites them correctly.
Okay. That's fine. I didn't cite an exact statute, but I appreciate your objection.
What was the statute that you cited?
MCL 657.6. I mean, not 57.6, 600.5716. I just said MCL
Objection
because
is
they're
the-
both under MCLs. Both proof of service and certificate of service are both under
No.
MCL.
No,
All right, well, everybody, so
You,
can I make my ruling?
like, let's just, okay. All I'm trying to do is ask questions to make sure certain things are on the record. A certificate of service
okay,
is
ask that question.
not on the disposition. And just like she read on 657, 16, was the property described on that disposition?
Yes.
Was there a description of the property?
Yes,
If there was a description of the property?
correct.
On my copy, there is no description of the property. But let's continue. Does your company participate in HUD programs or accept federal HUD assistance?
Yes,
Okay. Did you provide me with grievance procedures required by HUD?
did I provide you with what?
Grievance procedures required by HUD.
Your Honor, I object. That's irrelevant. There are no
It's
such grievance procedures under this anything that I'm aware of. I mean, I don't even know what she has a grievance about.
right. The grievance would be with the breach, and you all have a grievance, and hence on why you initiated a hearing for the breach of the contract. So it goes back to HUD because you're publicly funded, right?
No, we're not.
And-
No,
publicly-
we're not publicly.
Well, you accept HUD housing. You accept HUD housing and you apply and you are in compliance with HUD laws and policies, correct?
Yes,
Right. Okay. So if you have HUD terms and you're
Your Honor, I object. Miss Battle is taking.
object to it, I didn't say anything yet.
Well, I'm objecting because she asked Ms. Charles a question, which was, do you get any funding from HUD? Yeah, most companies do. We do. And then she takes that and starts taking that to a next question where it says, well, when you get funding from HUD, and then she's assuming.
I didn't assume anything. I asked the question.
Okay, what was the question you were going to ask?
I said, do you have to follow HUD's policies? That was my next
And
question.
she said yes.
Right. And then you objected after that.
No, and then you started the next question.
No, I started the question, but I didn't get it out my mouth
Everybody,
before you
please
objected
just
me.
Let her ask the next question, and if you have an objection, I can hear it after she finishes her question.
Okay.
Okay. Are you aware that before you initiate a hearing in court or the administrative process before court, you have to have an administrative hearing by a HUD administrative judge?
Your Honor, I object. I'm not aware of any.
Say no. I mean, that's
Just
not.
say no because you're not aware, and that's okay to not be aware. That just means that you are not aware of the laws that govern.
No, it doesn't,
It-
because
it-
it's not, that is not the law, ma'am.
How is it? Okay.
You're making.
Are you aware of the requirement under 42 USC 1437 DK for federally funding or accepted landlords to resolve disputes through HUD before an eviction proceeding?
Your Honor, again, I'm going to object. The fact that Ms. Charles answered the question about having a relationship with HUD doesn't mean we are a federally funded property.
I didn't say that you were federally funded. So let's be clear.
Just
I
read,
said either federally funded or get federal funds, which you do if you accept Section 8 and vouchers.
As the hearing continues, Karen brings up HUD grievance procedures, claiming the landlord must go through a federal hearing before eviction, even though that doesn't apply to her situation. She says the property accepts HUD and, therefore, must follow HUD protocol, but she herself does not qualify for those protections. The judge and attorneys clarify again and again, but Karen refuses to let go of her invented reality. Every time she's corrected, she claims they're lying, or that they don't know the law. Her belief in administrative hearings precedes actual statutes. She even accuses the court of violating federal regulations and threatens to file charges against everyone involved. It's at this point Judge Washington realizes the hearing is no longer about facts. It's about managing delusion. Despite the courtroom's patience, Karen cannot accept that her arguments are invalid and insists on dragging everyone through legal mud until someone agrees with her.
no, that's not true.
Why is it not correct? You had to think about it. Yes, it is correct. Because if you received any type of funds from HUD, which is through Section 8 vouchers or regular vouchers, you get what I'm saying? You receive funding from HUD.
We are, do you?
I'm not
receive
saying
voucher?
that I'm not saying that you're funded and that they give you loans of that nature. I am saying that you are within their practice and policies of HUD guidelines because you accept HUD in Section 8.
Your Honor, I object to this whole line of questioning. Ms. Battle does not receive a voucher, and so all of this questioning
Well,
is,
it doesn't matter if I receive a voucher. It matters that you are of that type of entity that needs to go through HUD because you accept those things. So
Your
you
Honor,
agree with those terms and policies of HUD.
Your Honor, she's making that up again.
I'm not making that up. If you're saying that, how am I making it up? It's under 42 USC 1437 DK.
Battle.
It's a
Ms.
federal
Battle.
registrar on it.
Ms. Battle, you've made your record. My ruling is still that every entity that has to file a landlord-tenant action does not have to go through that process to collect rent, ma'am. That is not how it works.
Okay. Okay. You're saying that it doesn't have to, but HUD
This is
says that
not a
these are
debate.
the
None.
requirements, hence why MCL at the bottom is trying to align with HUD guidelines on the same registrar that I'm talking about. You have those codes at the bottom that match up with HUD.
Move on.
Okay. So, well, obviously, if I can't really get a line of questioning, I'm being objected because he feels it's not right. He is objecting with no laws or facts behind anything he's saying. He's just thinking it off the top of his head. I'm not getting a fair hearing here.
She finally brings up one of her favorite soft set tactics, the idea that courts must prove jurisdiction to her satisfaction. Judge Washington tells her multiple times to move on, but she keeps coming back to it. Then Karen claims the whole court lacks integrity and insists she's being denied a fair hearing. She says she'd take the case to the US District Court and involve federal marshals, as if that's how eviction hearings work. She threatens to report the judge to the Attorney General and the IRS. She even says criminal charges will be filed against the opposing attorney for simply filing a claim. It's pure courtroom chaos, and the judge is done playing games. She warns her to stop interrupting or be silence. When Karen keeps talking over her, the judge orders her removed from the proceedings, and you can feel the relief in the room, like the tension finally broke under the weight of her nonsense.
Battle. Move on.
Move on. So, okay. Do you have a copy of the court establishing jurisdiction?
Who's that a question for?
Dawn, my plaintiff.
Your Honor, I object. The court's already said they have jurisdiction over the
The
property.
court said that she had jurisdiction because she said so, and that's non-judicial.
Okay. Ms. Battle, move on.
Move on to what? If I cannot have, this is not a fair hearing. And
No,
again, this is why
you're trying to turn this into.
I'm not trying to turn it into anything. I'm just trying to state the
Please.
laws, and I'm not trying to argue with y'all about anything. You get what I'm saying? I'm not trying to argue with y'all. I'm just trying to get y'all to state and prove y'all facts, and y'all have not proven any facts. But for some reason are hindering me in this proceeding. And that's why I took this case to the U.S. District Court in Eastern. That's why there's an open case right now with
Okay.
all of you all, because this is just not, and I told the Attorney General, and I told the IRS, and I did everything else, because at the end of the day,
Now, please
all
move
of
on.
this is not
I'm
right.
telling you
And
now
attorney
that I'm going to
grievances.
be filing criminal proceedings against you for all these frivolous things that you're filing against me. So
If you
please
feel that
move
it's
on.
frivolous, that's fine, but it's not. My
Well,
rights
this is
and
what the
my
Attorney
rights are
General
not
said.
frivolous.
Please move on.
It's honestly, if I can't have a fair hearing, nobody has any facts. Y'all talked about constructive possession. Nobody wants to talk about that. Y'all keep saying that I rescinded a contract unilaterally. That's not the case. It's called notice. And when a notice goes unrebutted, just like if I was to come here, if I was to get that notice of dispossession and get a notice of a hearing, and I missed that hearing because I did not rebut,
Yeah,
that would constitute
this
as
cross-examination.
Battle, if
that
you're
would
not
constitute
going to
as
ask
the same
appropriate
type of
questions, then I'm
fault.
just going to silence you. So you get the opportunity to ask your questions, or you can just be silenced.
I don't
Well,
have a real opportunity to ask the questions. So at this point, like I said, I'm just gonna have to get the federal court involved and get the marshals, because I don't know what you all are gonna do.
After removing Karen from the courtroom, Judge Washington grants the judgment against her. The landlord is owed thousands in unpaid rent, and the court cost adds up to a total. She now has 10 days to vacate or face repossession. Her defenses are ruled invalid and her counterclaims have no basis in law. The judge calmly explains that rescission doesn't apply and that she refused to provide any valid defense. Throughout the hearing, Karen says she wasn't given a chance. But the court record clearly shows otherwise. She spent more time citing irrelevant laws than presenting facts, and now reality catches up to her as judgment is entered. She tries one last time to explain that the property must follow HUD procedures because they accept Section 8, but the judge reminds her yet again that she doesn't even receive that benefit, so those rules don't apply to her case. It's the final nail in a coffin she built herself.
You all have not been acting in honor and with good faith. So I don't know.
I don't know
I'm
what's wrong
stuck
with
on what to
you.
do.
There's
The integrity of the
clearly
court is
something
questioned.
wrong with you. I don't know what that is, but you should seek some mental help, because something's
sorry?
wrong with you. You have
You
a
said
mental
what?
problem. You have a mental problem.
I
If
have
you
a
think
mental
the
problem.
laws in the
How?
United States don't apply to you, and you get to make them up as you go along, like you know more than everybody else in the world, there's clearly something wrong with you.
No, what did I make up?
All of it.
What? Be
Anyway,
specific. No, be specific, because
no.
now you're lying on the record. This is perjury. I didn't make nothing up.
Okay.
42 USC definitely applies to this case.
All right. I have
Jurisdiction is a threshold.
Ma'am, if you don't stop, I'm going to remove you from the court proceeding. So, Mr. Fantera, apparently we're not going to have a reasonable hearing here today because Ms. Battle feels as though the laws are very different for her as opposed to everybody else in the world. I'm not certain how to handle this going forward. You have submitted your documentation and she wants to argue stuff that's not law, regardless of my rulings. So therefore, I'm not sure what to do with respect to your case.
I would ask for a directed verdict. She hasn't said anything that is a defense to my action, and I submitted a proposed judgment this morning. There's rent owing in the amount of $3,432.42, court costs of $177 for a total of $3609.42. We would ask for a judgment for possession with a writ after 10 days, and she can avail herself of whatever procedures she can in another court.
So you're saying that none of my objections is valid towards your claim. So having a valid contract is not an objection. Oh, because you're saying that because a notice was given and unrebutted, it's not of law. That's what you're saying, right?
Yes, that's not the law.
It is. It's the law. It's Wells versus Zendaya of Michigan. It is. It's
All right.
backed in case law. And y'all keep muting
Ma'am.
me. It's okay. Because he can talk, but I can't talk.
Ma'am, you've argued that over and over, and I've ruled that it's not. You can file your appeals, file all the things you're filing, but when you file false liens against people, That is a crime. And I
It's not a
will-
false lien. You got defaulted on a private side, and you know that.
Okay, whatever. All right,
Yeah,
so
well,
what I'm going to do is grant your judgment in this particular case because I've given her an opportunity to present defenses that are real and she has refused to do that.
I didn't refuse to repent defenses. You didn't ask me about my piece of the case. I only got to cross-examine. You didn't ask me about my defenses.
What are your defenses, ma'am? And rescission is not one. I've ruled that it's not.
I'm sorry.
I know you heard me.
No, I didn't. You said, what are your defenses? And I didn't hear the
ruled
last
that
piece.
Your rescission is not a defense.
Okay, that's fine.
That is your defense.
Right, because, threshold matters are not an issue. But again, like I said, the fundamental objections and a counterclaim, object to the subject matter jurisdiction, you all accept and receive housing funds, making the
Your Honor,
subject
we're going
matter.
down the same road.
Okay, listen,
That's
stop. I
No,
didn't cut you off.
stop.
I didn't
I've
cut y'all
said
off. You
it's
just asked
not.
me what my defense was. And
All right, I'm done.
wow. You're asking me what my defense is. I can't.
Take her out. I've asked her 3 times to stop this. All right, I'm gonna grant your judgment in this particular case.
Your Honor, are you going to check the box after hearing?
Yes,
Thank you.
thank you.
I'm sorry.
Thank you,
had to
Judge
go-
Washington.
I'm
Thank
sorry you
you.
had to go through that.
All right, thank you.
Thanks.
Appreciate it. Bye.
We discover that Karen not only disrupted court, but also filed multiple frivolous lawsuits against the judge and others, including demands for $1 million and claims of constitutional violations. She even accuses the judge of perjury and insists she's entitled to security deposits for a lease she claims doesn't exist. Her filings are filled with sovereign citizen rhetoric like notices to agents and principals, demands for relief, and false claims about legal entities. One document even cites laws about mental competency that ironically apply more to her than anyone else. The judge has grounds to charge her under multiple McCalls for filing false liens and fraudulent statements, and the video ends with a warning from the judge not just for Karen, but for anyone thinking of weaponizing fake legal theories to avoid accountability. It's a wild ride from start to finish, and if charges are filed, we may just see Karen in court again very soon. So if you want to see more chaos like this, hit that like button and subscribe, because we've got plenty more where this came from, and trust me, you won't want to miss the next one.